Oh, I'm Tanya Iser. I'm a reporter here at Channel 8. I'm joined by Mike Casillas, who is a Dallas appellate lawyer, an expert in this area of the law, which is a really its own intricate, different legal things when it comes to appellate law. But I want to give a recap of this case. You'll recall Amber Guyger, Botham Jean. This occurred back in September of 2018. Amber Guyger says she's an off-duty Dallas police officer. She worked a 13-hour day. She says she parked on the wrong floor and went to what she thought was her apartment, and she shot what she says she believed to be an intruder. But that person that she shot was a man named Botham Jean, who was in his own apartment, eating ice cream and doing nothing to anybody when he was shot. And so a 12-member jury found that she was not reasonable in her belief that that was her apartment, and that she was not reasonable in shooting him. And her claim, of course, was self-defense. And so that's part of the claim that her lawyers are making today. And I also want to bring up, there was several things that that were brought up during the trial that that the prosecutors claimed were not reasonable. There was this red rug that was in front of his apartment. They're basically saying that there were other visual clues that she should have picked up on to know that this was not her apartment. And so Amber Guyger has been in prison for about the last 18 months. She received a 10-year sentence in a Dallas County court. And Mike, what are prosecutors going to claim today? What are we going to hear from them?
Well, Tanya, the prosecutors on appeal, since there was a conviction, are basically playing defense, and they're defending the judgment of conviction. So the big things that help a prosecutor, and I am a former prosecutor and current defense lawyer, is that the jury obviously accepted the state's theory of the case and found the state's witnesses credible. And on appeal, the appellate court will give a lot of deference to those kind of credibility determinations because the jurors were in the courtroom and saw the witnesses testify. And so on the defense side of it, they're going to be trying to claim that this evidence all clearly shows that this was a reasonable mistake of fact on the part of Officer Guyger. And the prosecution will get to point out that the jurors could have disbelieved certain parts of the testimony. In the state's brief, and I have read both briefs, the state goes to great lengths to point out that the facts that would help Officer Guyger with her claim largely came from her own testimony, and therefore the jurors don't have to believe her. And when you're a prosecutor, that's one of the strongest arrows in your quiver to fire, is to say, hey, the jurors found these witnesses credible. They don't have to find that witness credible. Additionally, the state is making a very interesting argument that a mistake of fact should not even have been given as a jury instruction. And there's some interesting law that they cite to, which points out that mistake of fact under the law must go to negate the culpability to commit the offense. And basically in this case, there's no doubt that Officer Guyger meant to shoot to kill. I mean, she was very consistent in it. And the state points out some other cases where mistake of fact issues were raised, and points out that this case law makes very clear that the mistake of fact must somehow negate the intent to kill. A good example I can think of, I haven't seen it in a particular case though, is somebody has a gun, they honestly don't know it's a real gun, and they just fire a shot at somebody else, and they, legitimately can tell you, I didn't think it was a real gun. I didn't even think it was loaded. And so that helps negate that intent to kill anybody. It's like you just thought you were pointing a toy weapon, and oh my goodness, it's a real gun. It fires, it kills the poor victim. So that's how mistake of fact, according to the state's argument, is supposed to work. And they do have case law that supports them on that. One of their cases involves shooting into a car and the defendant believing the car was empty. Now, you may have other crimes there, such as criminal mischief, but if you don't think someone's inside that car, it's certainly not murder to shoot into a car that you think is empty.
And so what do you think we'll hear from her defense attorney today, Michael MOWLA?
Mr. MOWLA is an excellent lawyer. I've litigated against him. I expect him to follow his brief. He has set out a number of facts, some of which don't even come from Amber Guyger's testimony, that he states help establish that her mistaken belief was reasonable, and that the state's evidence didn't negate this or didn't prove beyond a reasonable doubt that she was guilty of murder. Some of those facts, and this case really shows how you can mount a really good defense if you have the substantial resources. They went and interviewed residents at Southside on Lamar, and they managed to interview 297 of them. And something like 71 of them on floors 3 and 4 had admitted they'd walked to the wrong apartment or the wrong floor. Some 23% of them on 3 and 4 had gone to the wrong door and put their key fob in it. So, I mean, these are good statistical facts that help the defense argument. It's just a question of those other issues you alluded to, those factual issues about the vase, the floor mat outside the apartment. And to me, the biggest one is how, and I believe it's Officer Guyger's testimony establishes this too, that she put the key fob in and it showed red, which normally means that's not going to open the door. But they did have other people who had similar occurrences at the correct door. So there's all kinds of facts there to kick around. But as a prosecutor, you are defending the conviction, and that's an enviable position to be in when you're litigating.
Well, you and I were talking about this yesterday, that the appeals courts rarely overturn a verdict like this, or any verdict for that matter.
When it comes to a judgment of a criminal conviction, the statistics I've seen are that well over 95% of all appeals result in no relief for the defendant who's appealing.
It's very difficult to overturn a case like this, and I think also that you guys out there will remember there was a lot of things that happened in that courtroom that were really unusual. At the end of the trial, after Amber Guyger is sentenced to 10 years in prison, Botham Jean's brother, asked to hug her, and then we saw the judge come up and also hug Amber Guyger and give her a Bible. But we're not going to see, we're not going to see anything, because the court has decreed that we can use the audio from this hearing today, but not the video. But this is going to be, in many ways, the dry legal stuff today, right? I mean, that's what we're really going to hear.
Yes, Tanya. A lot of people have a misconception when they say, I want to appeal, or we want to take an appeal. An appeal is not a retrial of the case. Now, you certainly go back over certain issues and certain facts, but in most criminal appeals, you are trying to convince the appellate court that the trial court made some kind of mistake of law. And the other argument you frequently can make is that, okay, the state's evidence is legally insufficient for any rational jury to have convicted your client. During these arguments, you will not hear either side, either Mr. Gladden or Mr. MOWLA, jump up and object to something the other side is saying. You will sit quietly, you listen to your opponent, and then when you have your time, you make your arguments. And if you think your opponent has said something that is, not a fair recitation of the facts or not a fair characterization of the law, you point that out and you try to be professional about it. I've seen some lawyers who don't seem to understand that. You don't help your credibility if you look like you're trying to turn the appellate process into something more akin to world-class wrestling. But there can be heated arguments and there can be pointed questions from the court. This is something, too, that any of your watchers or listeners need to understand, that the justices may ask tough questions, may seem to be asking questions that indicate they're leaning a certain way, but that doesn't necessarily indicate how the judge will rule. I've had cases where the panel seemed to ask me every question I wanted them to ask and asked it in the tone of voice I wanted to be asked in, and they still went against me. I've had others, it felt like they were beating me up with all their questions, and then the opinion comes out and my side prevailed. So it will be a lot drier. If you've ever seen the movie Reversal of Fortune, there is an appellate argument in that movie, and it does a pretty good job of showing what an appellate argument would be like in a very microcosm version.
So we actually prepared a short video to explain what this appeal, how it's going to be structured. So Nick, do you want to go ahead and play that? It's pretty short. It's about a minute long. It'll just give folks an understanding of how this will go.
We wanted to take you inside former Dallas police officer Amber Guyger's appeal hearing for her murder conviction. Guyger was convicted of murder in October 2019 for the death of Botham Jean. Because of COVID concerns, all participants will appear via Zoom. The 3-justice panel from the 5th District Court of Appeals will hear the oral arguments. There'll also be Guyger's attorney and an assistant Dallas County District Attorney representing the state. A clock on the screen will keep time. Amber Guyger will not appear. That would have been the case even before the pandemic. The proceedings will be broadcast on the court's YouTube channel. Each side will have 20 minutes to argue before the court. Guyger's side will have an additional time to rebut the state's arguments. The justices can ask questions at any time, and they can add more time if they feel it's needed. After the hearing, the justices will go into a private Zoom conference to deliberate. And there's no timeline for when the justices must issue a decision. After the court hands down its decision, either side can appeal to the Court of Criminal Appeals in Austin. In Dallas, I'm Tanya Iser.
Mike, is there any likelihood here that in the unlikely event that the court threw this verdict out, which I think that based on statistics, that's really unlikely to happen, that based on what they're asking for, could it get taken back to the courts and she actually get a longer sentence, like a life sentence? I mean, because let's face it, the 10-year sentence was short on the spectrum of murder sentences.
If the defense wins on their first argument, the Court of Appeals would be issuing an acquittal. Now, they have a secondary argument which states that, if anything, she should have been found guilty of criminally negligent homicide, and that would be sent back to the trial court for the trial court to determine what punishment to assess. However, if the defense on appeal manages to win this case, the state would certainly file a petition for discretionary review with the Court of Criminal Appeals down in Austin. In fact, whoever fails to prevail on the case in front of the Dallas Court of Appeals is going to file a PDR. Now, it may not get granted. The Court of Criminal Appeals may not decide to review the case any further, but whoever loses this case being heard today, that doesn't end the appellate process because the state would certainly seek further review if they lost, and the defense has nothing to lose if they lose here by asking the Court of Criminal Appeals. In fact, Tanya, I did a little research. The Court of Criminal Appeals has agreed to review the prior case of Roy Oliver, who was a police officer in Balch Springs, who shot into a car and killed somebody.
Right.
And in doing my research, I saw where he was found guilty on August 28th of 2018, and Botham Jean died on September 6th of 2018. And the briefs have all been filed in that case of Roy Oliver. So without a doubt, whoever loses today, and we won't know for months who loses, is going to file with the Court of Criminal Appeals to try and review the case further. But yes, it is a high mountain for the defense to try and surmount.
Well, and I just, it'd be pretty shocking if they overturned it. I mean, it just doesn't happen very often. And you know, and it seems like we've seen a lot more of these cases going to trial. We just saw the trial wrap up in Minneapolis in the case of Derek Chauvin with the death of
George Floyd.
George Floyd, sorry. And you know, what a horrible case that was. And then, of course, you mentioned the Balch Springs case. Just all these cases are really horrible. How do you place this case in comparison to those other ones?
I don't know which legal issues they'll try to raise in the Officer Chauvin appeal, and of course there will be an appeal there. The Guyger case, to me, was truly a tragedy in the sense not only that Botham Jean died, but there was never anything to indicate that Officer Guyger had any kind of, you know, prior dispute with Mr. Jean. Nothing to show that she'd even known him. So, you know, as I watched parts of the trial, I had no problem believing that she really didn't realize this was not her apartment. But under the law, you know, the jurors determined her belief was still not reasonable, that she needed to defend herself with deadly force.
Right, and that was the ultimate question. I watched the entire trial too, and I have no reason to believe that she didn't believe that was her apartment, but it wasn't her apartment, and there was no testimony to indicate that she was reasonable in certainly in shooting and killing him.
And something else that I want to bring up, because I do know almost all these lawyers who were involved in the trial and on appeal. And I think the state had a real asset in their chief prosecutor, Jason Harmless, being a former Fort Worth police officer. And the state made certain to develop some testimony about police officer training and how police officers are also trained that you can stage outside a place and wait for backup and see what happens. And I believe, you know, I have no doubt in my mind that, you know, Officer Guyger has probably wondered why she didn't take that course of action.
I'm sure she's wondering, and so is the family of Botham Jean. And I've met them, and they are absolutely wonderful people. And this case was a tragedy all the way around. The live stream of the court hearing is just about to start, so I guess we'll stop talking so you guys can listen to the arguments from the attorneys. I believe that Amber Guyger's side is going to go first, then the state, and then we'll hear a brief rebuttal from Amber Guyger's attorneys, and then we may also hear questions from the judges.
That is correct, Tanya, and I have no doubt you'll get questions from the judges on a case like this.
All right, well, let's take a listen.
All right, good afternoon, counsel. Can you hear me okay?
Yes.
I can, Your Honor.
Okay. All right, then the court calls for oral argument, case number 05-19-01236 CR Amber Renee Guyger against the state of Texas. And Mr. MOWLA, you're going to have 20 minutes Mr. Gladden, you'll have 20 minutes, and Mr. MOWLA 5 minutes for rebuttal. I would ask that if you're not arguing, that you mute your camera and your audio both, please, if you're not arguing. So, Mr. MOWLA, you have 20 minutes, and if you're ready, you may proceed, sir.
I'm ready. Thank you, Your Honor. May it please the court, counsel for the state, Mr. Gladden. My name is Michael MOWLA, and I represent Amber Renee Guyger in this appeal. This is an appeal out of the 204th District Court of Dallas County, cause number F1800737. This is an appeal from the judgment and sentence entered on October 2nd, 2019, in which my client, Amber Renee Guyger, was convicted of murder under Texas Penal Code Section 19.02 B1 and B2. She was convicted as charged in the indictment, and the indictment recited and tracked Section Penal Code Sections 19.02 B1 and B2. In the appeal, I raised two issues for appellate review. In the first issue, I raised a legal sufficiency argument, arguing that my client is not guilty of murder under either 19.02 B1 and B2. And the second issue, I argued that as a lesser included offense of murder, if the court is inclined to not acquit her outright, they have the option under the facts and the law that I stated in my brief of criminally negligent homicide, and with a remand to the trial court for a punishment hearing. Now, Your Honors, this case—
Mr. MOWLA, can I interrupt you here before
Yes.
you get started here? I realize you have your two issues, but it would help me if you could address the state's cross issue on jury charge error first before you begin on your issues. I realize there wasn't very much addressed on that in the reply brief. So I'd rather you start with that, please.
I will, Your Honor. The jury charge issue, I raised it. I talked about it briefly in my opening brief. I did address it in my reply brief. In a legal sufficiency case, as the court knows, the issue is whether a defendant is guilty under the hypothetically correct jury charge. And under the hypothetically jury charge, I believe my client was entitled to a mistaken fact instruction. Under Hamill versus State, which is a 1996 Court of Criminal Appeals case, a defendant is entitled to an instruction on any defensive theory, including mistake of fact, if the issue is raised by the evidence, whether the evidence is strong, weak, unimpeached, or contradicted, and regardless of what the trial court may think about the credibility of the evidence. Now, the trial court in this case did allow the mistake of fact instruction. And I believe Granger versus State, which is a 1999 Court of Criminal Appeals case, addresses it thoroughly. In Granger, the defendant, as a Dallas County case, the defendant, one night when he was out, he shot into a vehicle that he thought was empty. Turns out there was a 72-year-old Vietnam veteran asleep in the vehicle without Granger knowing about it. Now, Granger was an issue regarding the jury charge, but since the state raised the issue as a cross issue, the Court of Criminal Appeals determined that Granger was entitled to a mistaken fact instruction because he did not know that the victim was in the vehicle when he fired into it. Now, what Mr. Granger did was facially illegal. You cannot, under any circumstances, fire into a vehicle, whether you believe there's someone in it or not. However, although he couldn't justify shooting into the vehicle, he could not be guilty of murdering its occupant if he reasonably believed that the car was empty, meaning had no occupants. In other words,
That's because murder is a result-oriented offense, and you kind of are overlooking that.
I don't think I'm overlooking it, Your Honor. It is a result-oriented offense, but the result in Granger still was that he killed someone. And the result in Ms. Guyger's case is she killed someone. The question is, was there a defense available in Granger? Is there a defense available in this case? And I think in both cases, it's clear that the statutory defense under Texas Penal Code Section 8.02A that addresses issue 1 is available to Ms. Guyger. Because if you look at what happened in Granger, for instance, and compared to what happened in this case, if Ms. Guyger had walked into knowingly or intentionally shot and killed a person. In this case, it was Mr. Botham Jean. A horrific result, no doubt. But if she had intentionally knowingly killed someone by intentionally knowingly walking into her apartment, she'd be guilty of murder. But if there was a mistaken fact, a reasonable belief of mistaken fact, which I assert she had, because I think the evidence shows that she thought she was walking into her own apartment. You know, just like in Granger, the defendant did not believe that there was anyone in the car. That's the type of mistake of fact that I believe Section 8.02 contemplates as set forth by the Texas legislature. Because in this case, if there's no mistake of fact, defense available, then there cannot be any justification for Ms. Guyger's actions. And she would be guilty of walking into another man's apartment and shooting that man, which is what happened here. However, you have to consider all the circumstances surrounding what happened. You know, now, just like in Granger, you know, there was some discussion regarding the circumstances surrounding, you know, what had happened. You know, again, you know, Mr. Granger did not know that there was no one inside the vehicle. Here, all the facts leading up to from the point that Miss Guyger entered the apartment, and, you know, that was laid out in the trial, how she was able to enter the apartment, how she was able to access an apartment that doesn't belong to her, the problems that Ranger Armstrong discussed that was with the strike plate on the deadbolt. You know, it turns out that Mr. Jean's door wasn't even locked properly.
Mr. MOWLA, you're overlooking the fact that Ms. Guyger testified that she intentionally shot Mr. Jean.
I'm not overlooking the fact, Your Honor. I agree she did intentionally shoot Mr. Jean because that was her intent. That was the truth. Okay, those were the facts of the case. If she had walked into her apartment and there was an intruder inside her apartment under Section 9.32A and Broughton, as I laid out in my brief, she would have been entitled to use deadly force in self-defense. Okay.
Well, you cite the Broughton case, but if you read the Broughton case, the defendant or the appellant in that case was mistaken about some facts, but not mistaken in fact, mistaken about some of the facts related to the self-defense claim. The defendant in that case testified that he thought the about to be decedent was reaching into a motorcycle side bag for a weapon and shot him, and the jury rejected that self-defense claim, which seems awfully similar to the jury's rejection of your client's self-defense claim here.
Your Honor, the self-defense, again, but the problem with what happened in Broughton is that the self-defense claim there was different than the self-defense claim here. My client, according to the facts, had a reasonable apprehension of danger when she walked into what she thought was her apartment. Now, again, if we agree that she thought she walked into her apartment, then the mistake of fact instruction applies. And then the question is, was her belief, was her apprehension of the danger reasonable? Now, the case law is very clear that I set forth in my brief and the reply brief that, you know, she doesn't have to be in actual danger, only apparent danger. Was that apparent danger reasonable? Okay. Now, the evidence presented during the trial showed that many other people inadvertently walked to the wrong floor of the Southside Flat Apartments. They walked to the wrong, or they drove to the wrong level of the garage of the Southside Flats Apartments. They walked to the wrong door. You know, one witness who, you know, this wasn't like some man off the street. This witness was an attorney here in Dallas that works for a civil firm. He testified that one time he walked into the wrong apartment and didn't realize he was in the wrong apartment until he saw a lady sitting on the couch looking at him with amazement. You know, so again, you know, the issue is, if the court believes that her mistaken fact in going to apartment 1478, which is one floor above hers the same side, same part of the building was reasonable, then the mistake of fact instruction applies. You know,
Okay.
Mr. MOWLA, Mr.
Yes.
MOWLA, would you address the case cited by the state in their brief, Solis v. State, a Texas Court of Criminal Appeals case, which is our precedent, with talking about the when you're entitled to that instruction on mistake of fact, that the kind of culpability is meant culpable mental state, which in this case is the intent to kill. In other words, there has to be evidence negating the intent to kill. Would you address our precedent in the Solis v. State case?
1 second here.
416 Southwest 3rd, 419, Texas Court of Criminal Appeals, 2013.
Yes, Your Honor. Your Honor, the issue is, as discussed in Solis, that there is other precedent that I address that I think is more applicable in this case. But in discussing Solis, there was an intent to kill on Ms. Guyger's part. She testified to it. Okay. The problem is, I think for the state's argument is that, again, if she had been in her own apartment, does the court believe that she would have had justification to shoot to kill? Okay, this is not a case, of where she emptied her magazine. There was a lot of stuff in the media about that. She fired 2 shots after she said, "Let me see your hands," twice. She walked in, she saw a dark shadow in the back. There was very little lighting. She said, "Let me see your hands, let me see your hands," twice. Joshua Brown testified, the witness that lived across the hallway, that he heard loud voices of 2 people that sounded surprised to see each other. Okay, so again, yes, she intended to pull the trigger. Yes, she intended to kill who she thought was an intruder in her home. Now, I'm not understating the fact that these facts have never happened before in Texas. Okay, there's never been a situation where a person that I know of in Texas walked into the wrong home, reasonably or unreasonably, and shot someone inside the home. That's never happened in Texas. So I acknowledge that she intended to kill because that's what she testified. The question is, and her getting to that point, when she walked into the wrong apartment because of the perfect storm, as Ranger Armstrong described, going to the wrong floor, walking down the wrong hall, coming to the wrong door, missing the clues of the vase that should have been there, missing the clue of the half moon red floor mat, missing the clue of the fact that, she was at apartment 1478, not 1378, which was the sign that was way up to her left. If she missed all those clues, was her entering the apartment believing that it was hers a reasonable set of facts that would allow application of section 8.02A? And I think that's a question for the court. And again, I acknowledge that she intended to kill. That's, I never stated in my brief that she didn't intend to kill. But the fact of the matter is, if she had picked up on any of those clues, however minor, despite the fact that many other people in the apartment building missed those clues when they were walking, although I acknowledge that, they didn't shoot anyone inside the apartment, understand that, she was a police officer. Okay. And, there's a police officer that testified during the trial that when you come upon a scene like she did, if it was a burglary call, then you would cover and conceal and wait for backup. But that same officer testified that if he had come upon his own home and he thought there was an intruder inside, he would go inside and go after the intruder. Okay, now,
Mr. MOWLA, aren't you erroneously mixing mistake of fact, defense, and self-defense justification? Those are in under two different titles in our Texas Penal Code. Mistake of fact is a defense, and self-defense is a justification. So doesn't the fact that she testified that she believed she was in her own apartment just go to whether or not she had a reasonable belief that she was in such immediate danger that she had to use deadly force? In other words, go to self-defense. So aren't you mixing those two?
Your Honor, I'm not mixing the two because I think the only way that what happened would make sense if you apply section 8.02A to what happened. 8.02A on its face, it's a defense to prosecution that the actor through mistake formed a reasonable belief about a matter of fact if her mistaken belief negated the kind of culpability required for commission of the offense. Okay, she was convicted of intentionally or knowingly killing another human. Okay, intentionally or knowingly killing another human is an evil act. Okay, that's what she was convicted of. The problem is that when she entered what she thought was her own apartment, she did not have evil intent when she entered her own apartment. Merely, again.
Just because of her alleged mistaken belief about where she was doesn't negate her intent to kill.
But Your Honor, it negates, my argument is it negates the mens rea, it negates the evil intent. Okay, because we wouldn't be here talking about this if she had walked into her own apartment. Okay, so she walks into her own apartment and she shoots and kills an intruder. Okay, here she walked into the wrong apartment, and in these horrific set of facts, she shot and killed Mr. Jean. The only difference between those two scenarios is her mistaken belief about where she was. Was that mistaken belief reasonable under the circumstances? Okay, now, there are many, many cases from the Court of Criminal Appeals that say that mental culpability has to be inferred from the circumstances under which an act based on a defendant's words, acts, and conduct. Okay, I don't think you can reasonably, or anyone can reasonably state that when you consider all the facts of the case, when you consider what happened, okay, that she had an evil intent when she walked into what she thought was her own apartment.
Mr. MOWLA, you're nearing the end of your time, and I know we need to get to your second issue concerning the lesser included criminally negligent homicide.
Yes, Your Honor.
Why do you think that you are entitled to that?
Your Honor, a criminal negligent homicide under section 19.05 of the Texas Penal Code and section 6.03D talks about inattentive risk creation or the failure to perceive a risk. Okay, as I explained in my brief in detail, I believe that Ms. Guyger at most is guilty of criminally negligent homicide because the evidence shows beyond a reasonable doubt, if the court were inclined to go this route, that she shot Mr. Jean, causing his death. That's undisputed. That she should have been aware that there was substantial unjustifiable risk of death from her conduct because she did not pay close attention or close enough attention to her surroundings and missed the clues of the vase, the red doormat, and the apartment number being off one digit. And the third is,
excuse me, Mr. MOWLA, what evidence do we have in our record that shows that if she is guilty, she is only guilty of the lesser included criminally negligent homicide?
Well, Your Honor, in my brief, I went through 47 or 48 factual points, 48 distinct factual points. I start on page 82 of my brief and go through page 99, pointing that what occurred was a clear mistake of fact, and she acted reasonably under the circumstances. Look, Your Honor, she missed basically 4 clues about where she was. Okay, if the question is, she should have been more attentive, and that was some of the state's argument during closing, that she should have been paying better attention to where she was. Okay, so that constitutes a failure to perceive the risk of her actions. That's why I believe that criminal negligent homicide is a viable option for the court as a lesser included offense. She should have been paying more attention. The bottom line is she was convicted of walking into the wrong apartment and killing the occupant of that apartment.
Thank you, Mr. MOWLA.
Thank you.
All right, if you mute yourself, please, there, Mr. MOWLA. And Mr. Gladden, you have 20 minutes and you may begin when you're ready, sir.
Thank you. May it please the court. My name is Doug Gladden and I represent the state of Texas. This is a murder case, not a criminal trespass case. When Amber Guyger shot Botham Jean, she didn't take someone else's property. She took the life of a human being. She took Allison and Bertram's son. She took Brant and Alyssa's brother. She took Alexis Stossel's friend. She took Joshua Brown's neighbor. She didn't make a mistake about that. She knew Botham was a living human being. She pointed a gun at him. She intended to kill him. That's murder. It's not negligent. It's not mistake of fact. It's not justified. Amber Guyger murdered Botham Jean. This court should say so and affirm the trial court's judgment. Now, this appeal is about the sufficiency of the evidence, so we have to look at the standard of review. And the standard of review is that evidence is legally sufficient when viewed in the light most favorable to the verdict. Any rational trier of fact could find all of the essential elements of the offense beyond a reasonable doubt, and could find against the defendant on any defensive issue beyond a reasonable doubt. Now, that standard matters here for two reasons. First, this court has to decide what defensive issues were raised by the evidence in the first place. And then the question is not whether the jury could find for appellant on a defensive issue, it's whether any rational jury could find against her. So starting with the first, mistake of fact was not raised by the evidence in this case. Now, in the briefing and here in argument, appellant says that this case is about mistake of fact, but it's not. Mistake of fact is different from other defensive issues. Most defenses say, yes, I committed the offense, but it was justified, or it was necessary, or I was under duress. Mistake of fact is different. It says, I didn't commit the offense because due to a mistaken belief, I did not have the culpable mental state. Now, culpable mental states are intent, knowledge, recklessness, or criminal negligence, and they have to apply to the result of the conduct, the nature of the conduct, or the circumstances surrounding the conduct. For murder, the mental state relates to the result of the conduct. That is, you have to intend to cause death or serious bodily injury. Now, appellant is saying that her mistaken belief related to her reasonable belief that deadly force was necessary, but reasonable belief is not a culpable mental state. It's a term that's used in the penal code as a part of defensive issues and affirmative defenses. Specifically, in this case, self-defense requires you to have a reasonable belief that deadly force was immediately necessary. That's not a culpable mental state. It's simply a defensive issue. There was no evidence in this case of any mistaken belief on appellant's part that would negate her intent to kill Botham Jean. She never testified that she believed Botham was an animal, like a bear or a dog. She didn't testify that she believed her gun was unloaded or that she had a taser instead of a gun. She didn't believe the apartment was empty or that Botham was wearing body armor or that she was shooting blanks or that she was aiming away from Botham. All she said was that she believed she was in her own apartment, and that doesn't negate her intent to kill. So this court has to decide whether mistake of fact was raised by the evidence in this case. This court has the responsibility to apply the correct law and do so correctly. Now, this is the state's cross issue, and we're not asking for an advisory opinion on this. Whether mistake of fact was raised by the evidence in this case is a legal question, and the state will benefit from it here because the question on the appeal is whether the legal sufficiency analysis should look at the mistake of fact defense at all. Now, in the reply brief, appellant says this court has no jurisdiction on this because under Saghelm-Mabel, the state is asking this court to review an alleged jury charge error to provide guidance and prevent errors in the future. No. In Seg-Hellmabel, the instruction was on an evidentiary issue, specifically whether the defendant's statement was voluntary. That's not an element of the offense, and it's not a defensive issue. And the appellant in that case didn't raise anything related to the instruction on appeal. Here, appellant is challenging the sufficiency of the evidence, and she's arguing mistake of fact. Whether mistake of fact was raised by the evidence, then, is what this appeal is all about. Now, appellant says that the court can deal with this issue simply by deciding whether the jury erred in finding against her on her defensive issue. But this court can't deal with the issue that way. To do that, this court would have to say that mistake of fact was a defensive issue that was part of the hypothetically correct jury charge. But mistake of fact wasn't raised by the evidence. Since it wasn't raised by the evidence, this court cannot write an opinion that both sets out a hypothetically correct mistake of fact instruction and correctly applies the law in this case. This court would be left doing what the trial court did, which is applying the wrong law and doing so badly, and saying that if the appellant reasonably believed that she was in her own apartment, then the jury would have had to acquit her, even if the jury found that she committed murder and that it wasn't justified. And that's not the law. So that leaves self-defense as the only defensive issue raised by the evidence. And the standard of review matters for that, because the question is whether any jury could have rejected appellant's self-defense claim. The only evidence of self-defense in this case came from appellant's testimony. She said that she believed Botham was in her apartment, that she commanded him to show his hands and he didn't, and that he quickly moved toward her while saying, "Hey, hey." But the jury can disbelieve any or all of a witness's testimony. And if the jury didn't believe appellant's testimony, then there's no other evidence of self-defense, much less insufficient to reject self-defense. And all the other evidence in the case contradicted appellant's testimony. No one heard her give commands to show hands. Botham didn't have pockets where he could have hidden his hands. The trajectory of the gunshot wound means that he wasn't quickly moving toward her. And no reasonable person would have mistaken Botham's apartment with the red doormat, the backlit room number, the flashing red light on the lock, and the marijuana smell as her own. So then there are the elements of the offense that the state had to prove beyond a reasonable doubt. That appellant intentionally caused the death of an individual. Appellant admitted that she was the shooter, and the bullet in Botham's body came from her gun. She intentionally did it. She admitted that she intended to kill Botham. She shot center mass. She shot him with a firearm, which is a deadly weapon. She shot at a downward angle, and she didn't render first aid. She caused his death. He died of a gunshot wound. The gunshot came from his gun. And Botham was an individual. His sister testified that he was a human being who was alive. She spoke to him that same day, and he was excited about eating ice cream. The evidence in this case is sufficient to prove the elements of murder and to reject appellant's self-defense claim, and mistake of fact was not raised by the evidence in this case. I would ask that this court affirm the judgment of conviction. Does the court have any questions?
Do you have any, I'll have to go back and reread your brief, but was there any particular cases that you cited to, assuming the court wants to sustain your cross issue, anything in particular that you wanted the court to address, or any precedent that you think is most appropriate to apply?
The most appropriate precedent to apply is, I believe it's pronounced Pfeiffer v. State, that says this court can appropriately address a cross issue if the state would benefit from it on the resolution of the appeal. And the reason why the state benefits here is that this court has to decide whether mistake of fact was even part of the hypothetically correct jury charge that this court is going to analyze the sufficiency of the evidence on.
I guess what I'm kind of asking is, Mr. MOWLA mentioned in his argument that he couldn't find any particular case kind of on point factually. Are there any cases that you know, like the Broughton case that he cited in his reply brief, I thought was actually on point for you, Mr. Gladden, or for the state. Are there any other cases that talk about mistake of fact not being appropriate? A mistake a mistake of fact regarding the reasonableness of the use of force, but not a legal mistake in fact.
Yes, Chief Justice Burns. I'm sorry, I misunderstood your question. There's a line of cases that talk about that. Broughton is the primary one. We have the lower court opinion that specifically says that a mistaken claim raises self-defense rather than mistake of fact. In the supplemental letter brief that I submitted to the court, there's two additional cases. One is from the 14th Court of Appeals, Rocha v. State, and then the other is from the Fort Worth Court of Appeals, Maupin v. State. And both of those cases recognize the same thing, that a person who claims that a mistaken belief about the reasonableness of their conduct is not a mistake of fact when you're talking about a result-oriented offense. It simply raises a defensive issue, whether you're talking about self-defense or defensive property. And then I guess what you would call the big case that supports all of this intellectually as an underpinning doctrine is Shaw, because Shaw makes it very clear that when you're talking about a justification defense, like self-defense, Shaw was talking about, I believe, necessity, but either one, you're talking about necessity, justification, or self-defense, deadly force and self-defense, defense of property. Those are justifications under Chapter 9. And Chapter 9 says that it's a defense to prosecution that the conduct was justified. And what Shaw points out is that conduct means an act and the culpable mental state. So if you're claiming a mistaken belief that negates the culpable mental state, you don't have criminal conduct to justify under Chapter 9. And that's why, as Justice Myers said earlier, these are in different chapters of the Penal Code. These are separate defensive issues, and you can't shoehorn mistake of fact into a justification claim.
Thank you.
Mr. Lyon, I have just one comment.
Yes.
Thank you very much for an excellent written brief. It was very pleasing on the eye. As a matter of fact, I had my attorney look up what font you used because I liked it so much during late nights. That's appreciated. So thank you very much for the written brief and the letter brief, the letter as well.
You're welcome. And thank you, Justice Partida-Kipnes.
All right, any other questions? All right. Well, thank you, Mr. Gladden. Oh, sorry.
Thank you.
Thank you. All right, Mr. MOWLA, come on back. There you go, sir. All right. And Mr. MOWLA, you have 5 minutes for rebuttal, and you may begin. Mr. MOWLA, I think you're still muted.
Can you hear me?
Yes, sir. Gotcha.
I have nothing further, Your Honor.
Okay. All right, then. Oops. Now I'm having there we go. Now I'm having a technical problem here. All right, then. I guess we're done then, and I thank both sides for excellent briefs and an excellent presentation today. We will be in recess in this matter, and we'll take the case under advisement, and we will issue our opinion in due course. The case is submitted. Thank you. We're in recess.
Thank you both very much.
Thank you both for excellent arguments. Thank you.
Okay, so that actually went pretty fast. I knew it wasn't going to last very long, but it actually went a little faster than I thought. I think what struck me was that Mr. MOWLA got a lot of questions and was interrupted very quickly. I believe it was by Judge Myers. He questioned pretty thoroughly about whether or not they were mixing defenses and justifications and that sort of thing, whereas Mr. Gladden was allowed to speak until he was done. What do you make of what we just saw here?
Well, Tanya, having gone through this process many times, we refer to it in the practice as having a hot panel versus having a cold panel. There are times when you think your position is going to prevail and you want a cold panel because it's just so obvious you're going to prevail. There are other times when you want a hot panel because you think it's an interesting issue and you want to know that the court shares your interest in it. As I pointed out before the argument started, you can't always take the tone and tenor of the questions as indicating how the court's going to rule or how a particular judge is going to rule. But if I were the prosecutor, I would walk out feeling very comfortable after this argument.
Somebody is asking about this whole mistake of fact issue. Am I correct in understanding that the state is arguing that mistake of fact shouldn't even have been part of the jury charge?
That is precisely what the state is arguing, and the way they have gone about it is just indicative of what a good lawyer Mr. Gladden is, because on a sufficiency review, the appeals court is supposed to come up with what would be the hypothetically correct jury charge. And what that means is you have all this case law from the past where some things that got put into the charge shouldn't have been there, something that made the state have to prove something they shouldn't have had to prove. And when it went up on appeal, the courts would say, well, no, we measure it by that charge that was actually given. And then years ago, the Court of Criminal Appeals finally said, no, when it comes to sufficiency, you're supposed to consider what the correct, hypothetically correct jury charge would be, and then you measure the evidence by that. And so since Mr. MOWLA from Ms. Guyger is arguing legal sufficiency, that puts into play what would the hypothetically correct jury charge be. And so Mr. Gladden is arguing, hey, it shouldn't have had mistake of fact. And the reason it shouldn't have had it is mistake of fact, under the case law cited by Mr. Gladden, is supposed to go to negating that intent to commit the crime. So with Officer Guyger's situation, her admitting, yes, I meant to shoot and kill, and that's obviously what happened, it didn't negate that. It was, I thought I was shooting to protect myself in my own apartment. So as those examples I talked about before the argument started, shooting into a car you truly believed was empty, it might be other crimes, is not necessarily murder, because that fact that you were mistaken about could negate your intent to kill.
So who do you believe is right? Mr. Gladden or Mr. MOWLA? Is mistake of fact a reasonable justification in this case?
Not under the law as it exists.
Okay. And that was interesting because, these are really complicated parts of the law, right? I don't think I'd ever really dealt with this whole concept of mistake of fact prior to the Amber Guyger trial. And one of the things that MOWLA said was basically if the justices believed that she believed she'd walked into her own apartment, then mistake of fact applies. And then you have to decide if her actions after that were reasonable. What you're saying is mistake of fact doesn't apply and shouldn't have even been part of the jury charge.
Well, and I can understand why the trial court did it, because you basically immunize the case from a claim on appeal that, oh, the charge should have been given. Well, if the charge got given, then there's no error in the trial courts having refused to give it. And a lot of times trial courts will do that. They'll be like, okay, maybe this is close, maybe it's not exactly applicable, but I'm going to give you that. And
kind of like a mulligan? Like a mulligan, kind of? Like a mulligan?
Not so much a mulligan. It's more that, okay, defense, maybe under the law you're not exactly entitled to that, but this is pretty close, so I'm going to give it to you, knowing full well that if you kept it out and you should have given it, that might get the case reversed on appeal.
Okay, so in a way, it makes sense from that perspective for the judge to have included it. Just, okay, guys, y'all want to make that argument? But it was pretty clear in watching this trial that the jury, because we actually, at Channel 8, we actually interviewed a couple of the jurors. They believed that she did believe it was her apartment, but they just didn't believe she was justified in shooting him. And that's what it all boiled down to. And it also seemed like that they, that's why they came to the decision in terms of the length of the sentence. If you were ballparking this, how long do you think it'll be before we'll hear from the justices on a ruling?
I would assume you're going to have to wait at least 6 months for an opinion.
Wow, that's a pretty good amount of time, but actually not unusual. So, it was interesting to me that Mr. Mr. Gladden, okay, so he went for about 8 minutes with no questions, and then the judges had a few questions. And then he talked for a few more minutes, and then he actually quit. He had 8 minutes left. And then Mr. MOWLA didn't come back and add anything. Does that surprise you?
Not really, Tanya. I mean, a lot of us appeal lawyers, we have only so many things we really need to say. And so we try to say them and then not take up the court's time with just, taking the air out of the room. Years ago, when I was still a prosecutor in Fort Worth, a very good defense lawyer made his arguments. It was exactly the same as what he made in the brief. I had filed my brief. I was standing up to the podium and I said, unless the court has any questions, I have nothing to add to my brief and I'll stand on my brief. And so then he didn't do any rebuttal. And afterwards he told me, I've been doing this 30 years, Mike. I've never seen a prosecutor do that.
Well, and it seemed like I guess I was kind of surprised at how quickly the justices jumped in. I guess I have not watched a lot of these, so I don't know that I knew what to expect. Of course, I've covered a lot of trials, but appeals courts are just not something we really cover that much. And maybe that's something we should cover more of, but we just traditionally haven't. And so I wasn't actually sure exactly, how it would go. It sounds to me like also that they're saying that mistake of fact and self-defense are just like, they're also in two parts of the penal code. So these two are not supposed to ever mix, basically.
That is their point of view so far. That's definitely the state's point of view. And I will give Mr. MOWLA credit in that I've never come across a case like this where someone goes into the wrong house believing it's their own place and shoots somebody else. So, it is truly unique in that regard. And in the briefs, both sides were kind of having a dispute over a case from Britain, which didn't involve anybody getting killed, but it involved property damage to one house where the person doing the damage thought they were going into another house where they had permission to go into anytime they wanted. Because that's just shows how far-flung this set of facts is.
Yeah, I don't think I've been a crime reporter for, I hate to age myself, about 25 years. And no, this is not standard stuff. But I also think when the jury heard this case, they looked at the fact that she was a police officer. She had more training, a lot of training that average folks like us wouldn't have. And I think I think the prosecution made a pretty good argument that there was a reasonable expectation that she could have backed out or not entered. Because one of the things that was testified to during the trial was she made an affirmative decision to go ahead and enter that apartment. When she gets to that door, and of course there was an issue with the door not locking, but she makes an affirmative decision to go ahead and open that door and go in. And I think that was part of the thought process for the jurors when they made their decision. That she could have, there were other things she could have done. But I also want to say that I don't think we can ever lose sight of Botham Jean. After he died, I was one of the reporters. I was working that weekend, and it was a really rainy weekend, and I went and covered the prayer vigil that they had at his church. And I mean, what an amazing guy, amazing voice, Bible study leader. I met his mom, just wonderful people. And I do think that in all this, we have to remember and lost his life, and that it was a horrible thing that happened. And, you have to get beyond some of the legalism and the arguments and remember Botham Jean. Okay,
let me go ahead on that real quick, because I know some people who work in the criminal justice system, and please understand, I don't subscribe to this point of view, but they tried to argue with me that Officer Guyger shouldn't have even had to gone to trial. And I was just like, but Botham Jean was a person sitting in his own apartment.
Right.
How in the world can you say that you should even exempt Officer Guyger from a trial? That's why we have a system. We give it to a jury, and a jury makes their decision. And right. It's cost me friendships, because I can't maintain friendships with people who really adhere to that attitude.
Yeah, it was interesting. During the trial, I had a number of law enforcement officers reach out to me, and people that knew Amber Guyger. And, when they heard her testimony and they heard the entire trial, it changed some of their minds. I think a lot of the people I know ultimately understood and agreed with that trial, that jury. I mean, that jury had an unenviable decisions that they had to make. But I think the thing that will always stick with me is, we were live casting, is when, you can't ever forget the hug. And Botham Jean's brother is, that will always stick with me. That is it doesn't change the fact that Amber Guyger has to pay for what happened. It was an amazing display of forgiveness that still stays with me to this day. I wish I could be like that, or I'm going to strive to be more like that. Okay, so one more question from Facebook. Somebody wants to know, what would her new sentence be if her conviction was overturned?
It would have to go back down to the trial court for another hearing, so we wouldn't know for a while.
So it'd be, and then again, as you said earlier, 3 to 6% of cases get overturned. So it's a really rare thing that occurs. It doesn't happen very often, and I would frankly be pretty surprised if it happened in this case. Is there anything else I should ask you? And then before I wrap up.
No, Tanya, I think, and I think y'all are doing a good service by showing this appellate process to a wider audience. Like I said at the start, a lot of people think that it's some kind of retrial, and it's just not. I mean, you're stuck with whatever facts were developed during that trial and are in that factual record, and that's what you have to argue from.
Absolutely. So if folks want to know more about the case, you can go to WFA/Botham Jean. That has all of our reporting. And you can also go back and watch the trial on our YouTube page. We covered every moment of this trial. And I agree. I think this was the first trial that we had ever done sort of court TV style play-by-play coverage. And I think that it had a lot of benefit. And we later on did it with another trial of a little girl that was murdered. And I know that we hope to do more trials in the future. With the pandemic, it has made it a little bit more difficult to do, as you can imagine, but we do definitely want to do more of these. Mike Casillas, thank you so much for joining us. I know that taking time out of your day to explain these, difficult legal issues, and we'll just wait to see what the court decides. Thank you so much.
Thank you for having me, Tanya.